Richard, we have come to the last session here of what is, at least for me, but just an immensely fascinating and rewarding day. And we wanted to put aside some time at the end, um, not to summarize, because there's been so much that's been said, but to look forward. And as I said at the outset, for those of you who were with us back at 10 o'clock Eastern time when we began this day, that the Center on the Legal Profession really has these sort of three broad missions. It has research, it has teaching, and it has what we call bridging or connecting communities together. This seminar has been, I think, a magnificent example of the importance of that bridging function, of getting a conversation going across different lines, across geographies, across the bench and the bar, the academy and the profession. And we certainly want to continue that discussion. And I'm going to ask Richard towards the end of our last session to talk a little bit about some of the efforts that he's already have underway in his remote court worldwide community that he's put together. But I've asked one of my terrific younger colleagues to come and talk to us for a little bit about some of the research that he's doing that really directly goes to some of the key issues that we've talked about here, including one that came up repeatedly during the practitioner segment around how do you think about conducting online credibility assessments of witnesses? How do you think about, maybe it'll work in an appellate context, but not in a trial context? And my colleague, Jim Greiner, who is really doing pioneering research on a range of issues, trying to bring serious empirical techniques, including randomized controlled experiments of the kind that we see in many other areas, to law and legal questions. And I know because he and I were on another Zoom in which we were talking about some of these issues that he has some fascinating work that he's been doing. And so he's agreed to pop in, which I see him. I'm not sure if we're going to see you, Jim, or we're only going to hear you on the screen, but he's going to talk a little bit about the work that he's doing, and hopefully that will both prompt some further exchange and ideas. So, Professor Greiner.
Thank you, David. Thank you, Richard. It's terrific to see you. Good to see you, Harold. And I appreciate the opportunity. I am sorry that I was not able to join you earlier this morning. And so I fear that if some of what I discussed this morning, some of the themes are or this afternoon are repetitive, I do apologize for that. I was teaching this morning and so could only join you now. Very briefly, the research that the Access to Justice Lab, which I direct, is pursuing is structurally attempting to investigate two issues. First of all, to what extent can we move court procedures online and preserve values that we want preserved and further values that have been insufficiently furthered in our current setup, which privileges live in-person interactions. And second, to what extent can we or would it be a good idea to make some court proceedings asynchronous? And I suspect that both of those themes have been front and center in this discussion this morning. To add some specificity to them, we are attempting to implement, we have not gotten there yet, we're attempting to implement or in early stages of implementing a study with the United States jurisdiction, in which we would randomize whether jury trials are online or whether they are in person in a traditional format. The impetus for this, unsurprisingly, was the pandemic, because if you think about the way we do jury trials, especially jury selection, a jury trial is an instantaneous super spreader event of COVID-19. There is no better way to spread a disease than to get a cross section of the community together and force them to sit in close proximity in a poorly ventilated courtroom, and then decide that you didn't need 90% of them in the first place and dispense with them because that is roughly for the fraction of people that we call to jury duty and then send back, at least to the United States, because we will no longer have them served, and then send them back into their respective places in the community from where they came. And so that's again, from a public health point of view, that's a tremendously awful idea. And so given that the court systems, many court systems in the United States are currently shut, including the criminal system, they cannot reconstitute jury trials, and speedy trial values have been sacrificed. What can we do to resume the criminal system with the jury trials that it needs, and in addition, thereby unpack and unclog the civil system, because the same courts that are shut down and with the criminal cases in front are adjudicating the civil cases, and the civil cases can't get through until the criminal cases do. And so that has given us the idea of, which was around for a long time, of online jury trials and attempting to investigate those. And then the idea, well, if this was a good idea during a COVID or a pandemic context, what about when we emerge from a pandemic context? There are a series of objections to the idea. I tend to categorize them into some, in order to understand them, into some discrete categories. Some are, can we do this well? And the answer is yes, if we have the right technology. So things like preserving attorney-client privilege communications between a defendant and the attorney. That can be done well with technology. It does require attention to it. Can we get everybody heard? Can we see the witness clearly? Can we hear the testimony clearly? Can we solve the digital divide that might divide jurors from the court proceedings? Those are all implementation issues that we have the ability to solve. The question is, do we have the commitment and the funding that they might require? Then there are some other questions that that are already heard in the few minutes I was able to join you with this afternoon. I heard considered. So the legalities in the unique United States context, when we have quote unquote confrontation clause values in the criminal context. And so does the right to confrontation, for instance, of a witness against you, include the right to confront the jury, or is it just the witness? And if the confrontation does include the right to confront the jury, does it include, is a virtual confrontation sufficient, or does it have to be an in-person confrontation? These are all areas in which there is some case law. Most of the case law is dictum, but we have examples from United States courts of fact-finding, not jury fact-finding, but fact-finding that has been done with judges in, say, suppression hearings, hearing from witnesses via closed-circuit television or via internet link. And so this is hardly a revolutionary idea, no completely new idea. But we can look behind those legal concerns and say, why would we have an instinct that says that we need an in-person interaction? And there, I think, the primary, an example of one primary concern is deception detection. And this is what David was referring to previously. I've had a chance to do some research into the existing state of knowledge on deception detection. And there is absolutely no evidence to suggest that in-person interactions facilitate deception detection and therefore truth-finding, the jury's truth-finding function. In fact, all of the evidence that does exist is that deception detection is equally effective online or in even with reading a transcript. But the better way to put it would be to say equally ineffective, because it turns out that human beings are just simply awful at deception detection. The literature that I've read thus far coalesces around a successful deception detection rate of around 54, 55%. So a few percentage points better than a coin flip in terms of deception detection. In case you're wondering, there is no evidence that professionals who repeatedly encounter these situations do any better than lay people. So there's no evidence to suggest, in fact, there is some evidence the contrary. Judges are no better at this than jurors. There is no evidence to suggest that groups are better at it than individuals, except when groups have prior interaction. Then groups know each other, which is precisely what we don't do with juries. So that is an example of considering the structural reasons why we might have legal protections that would prevent us from moving to an online environment, and hoping to say, well, maybe we can think of those and take those into account when we are understanding the extent of the application of those legal principles to a new type of environment like an online jury trial. The other structural element here that I mentioned to begin with was asynchronicity. In other words, the idea of recording a jury trial and having individuals watch it, maybe giving jurors 3 or 4 days to watch the jury trial, and then maybe having them debate or deliberate synchronously, but having them watch a recording and then rendering a verdict and that way. There are, again, there is little evidence on this, and I think we should be cautious in rejecting solutions as to which potential solutions to problems as to which we have little evidence. In particular, it might be that, for example, allowing asynchronicity and virtual interactions would would solve problems of unrepresentative juries that plague the United States legal system, because people who were unable to participate in juries in person or even synchronously might be able to do so asynchronously. That said, deception detection and truth finding is not the only value. And again, I did hear this in the few minutes before I was able to log in. The judiciary has neither the purse nor the sword, and must therefore rely on persuasion and majesty. For majesty's sake, I could not agree more with Richard to say that is not a value that we want to further. Nevertheless, the example of religion and the important role that ritual plays in religion persuades me that we should also empirically investigate whether we need ritual or some kind of solemnity, which I think is the value that you articulated, Richard, in order to persuade the public that we are doing something that is important and worthwhile, even if, in the end of the day, the deception detection is little better than a coin flip. And it may also be, and this is part that I find nauseating, it may also be that the solemnity and the ritual impress upon the public the idea that there is deception detection going on even when we cannot accomplish it. And so there's a sort of false consciousness there, which again is poisonous in many ways. On the other hand, if people are more likely to tell untruths when they know we can't detect deception, that might be a bad thing for the legal system. And so these are all investigations that leads us to, in our investigations, to try to measure various outcome variables via surveys of jurors, via surveys of litigants, via surveys and also of judges and lawyers, and also looking at outcomes of cases themselves when we randomize them to different conditions. And so that's the research we have going on. And I hope that's what you were after, David. Let me turn it back over to you.
That is exactly what I was after. And I think even Richard, I think you've given him a lot to think about. And so I'd actually like, Richard, if you have some reactions to what Jim is doing, and not even so much even the conclusions, but what should we be looking at? Are these the right questions that we should be investigating in order to figure out whether we are moving in the right direction in this area?
Jim, that was really great on a number of levels. I think the first thing to say is methodologically, it's just so important that this work goes on. We have to move beyond anecdote and instinct of lawyers, and even without consultation with court users, to actually getting some serious empirical studies about what's working. We've done a little bit of this in the UK, and you'll see in remote courts worldwide, there's more of that. But isn't it in all our minds just now, in relation to vaccines? I think we're all so very conscious of the importance of serious, rigorous, systematic investigation. And I can't tell you how many very respectable judges and lawyers, from their own very limited point of view, in a very articulate way, will express a view that is simply not grounded in anything other than their own very limited experience. So the kind of work you're doing is absolutely vital. And it's vital that it's done internationally. For the first time ever, in a way, our policymaking about the future of courts and justice systems can be evidence-based. And this I find tremendously exciting, on which, incidentally, a point that not changing your justice system or your court system is as much of a policy choice as changing it. But there actually isn't much of an evidence base for staying as we are. There may well be a preference psychologically for staying where we are, but we've got to be driven by the kind of research that Jim's undertaking. So the first point is that it's so important that institutions such as Harvard are delivering authoritative research in this area and takes us beyond anecdote. Second point is, and I just never thought of it, the idea when we're talking about asynchronicity, the idea, and I have to take some time to think about it in more detail, but the idea of recording a criminal hearing and the, as it were, the deliberation of the jury and the observation of the jury taking place at a different time and place is completely fascinating. Again, the initial instinct might be, well, hang on, that's not a jury of the peers operating in the traditional way, but the mindset has to be, why not? Going right back to what you're saying, this should be driven by the values that are important to us, and in my view, the outcomes that are crucial for us, rather than how does it match up to what we've done, as Jeffrey said, for the last 150 years. So that fascinated me, and I'm going to give that a lot more thought. Now, Jim, I'm hoping you and I can have a conversation at another stage and link up to some analogous UK research. Thank you.
So, Jim, thank you very much. And Jim is always pushing us to really think rigorously on all sorts of legal questions. And Jim, you're, of course, welcome to stay and participate, but I'm going to ask Richard something that may also be helpful to say a little bit more about how you think we can move this community forward and this discussion forward. And you've mentioned here or there about remote courts worldwide, but maybe if you could say something more specifically about that. And then maybe a few words about what you would like to come out of this discussion, where we have had, again, so many important people in so many different places of the world tuning in.
Well, thank you. Remote Courts Worldwide was set up in the middle of March as a response to the move internationally from many jurisdictions away from physical courts to remote courts. And I mentioned earlier, audio courts, audio hearings, video hearings, and paper hearings. The sense I had was that there was a great movement towards remote courts, but everyone was reinventing the wheel, duplicating efforts. So I thought, how can we at least pool our resources? So it was a joint effort. The Society for Computers and Law, Law Tech UK, British government put money into it, Ministry of Justice, and we put together what is essentially a website, the first generation of which invited people to submit news of how they were coping, to submit commentary, to submit their own draft protocols and so forth, just a forum to which people could go to get a sense of what's happening and to pick up some insights. And in that first wave, we've got 56 different countries represented. It's quite unstructured in the first wave. So we're just about to start a second wave where there'll be technical improvements, better navigation, better search, but we're also trying to involve the community who've contributed in identifying the key issues that remain to be resolved and in having online debate about how we might resolve them. I'm also wanting to extend from what is, I think, 57 countries up towards 100. It'd be great if we've got worldwide coverage. So the idea there is to, as I say, to capture current practice and allow people, and I've had great feedback from judges, particularly around the world, to say we can just dip in there. As a reminder again, www.remotecourts.org. You can just dip in there and get a sense of what's actually happening. So that'll continue, I think, as a useful resource. What occurs to me as I listen to the conversation today is there's almost two entirely different communities here. There's a community of clients who are represented, and there's a community of clients who are either self-represented or frankly are not even clients at all. They're people with, I think, justiciable issues that never get near the justice system because they don't understand they've got issues or they wouldn't be able to enforce them. And a lot of our discussion today has been about how lawyers can represent their clients through remote hearings in the COVID period. And of course, we need to, I think, make sure, as others have said, that we can stabilize our current ad hoc systems and we can industrialize what's gone well. But my passion in all of this remains, well, let me put it a different way. I think in many ways we've seen that law firms and judges can look after themselves. They've been remarkably resourceful. I think if there's an effort required, if there's an intervention, as it were, that we as a global legal community can bring about, it's to helping people who actually have no access to justice. I go back to the OECD figure. Less than half the people in our world live under the protection of the law. More people, in fact, have access to the internet now than have access to justice. And I, therefore, am interested in the use of these technologies. It's not I'm not interested in law firms using them, but I'm interested in how we might increase access to those who don't have access and how we can help the self-represented. And I hinted the last time, and it's also in the last chapter of my book, and I've since been speaking to a number of the big development banks who are similarly interested, whether or not there's some kind of generic global platform, technology platform, that we can put in place that's tailorable for the substance of the individual rules of procedure and laws of individual countries, but enables people to kickstart their move into this virtual world. Very often we get visitors to London who want to see our court system in action, and we take them to the wonderful buildings and so forth. But I do say to them, and I think this reflects a view of the development banks, that the opportunities here is to leapfrog. We as a jurisdiction, although we've got the big buildings, are thinking how we can increase access through remote courts. Why don't you do similarly? But when you think of the technology required, the insight, the experience and so forth, very hard to do that from scratch. And it just seems to me to be a glorious duplication of effort if lots of developing countries are doing this. So the charity I'm thinking of setting up, supported by various law firms and so forth, and I'd love anyone listening in to participate too, is to look into the feasibility in the first instance of establishing some kind of generic, tailorable platform that would allow developing jurisdictions very quickly to introduce, perhaps it be video hearings in the first instance, or it might just be simple diagnostic tools, but we'd put in place this platform that would mean the introduction of this innovation as something that can be done in a modest number of months rather than a formidable number of years. And so my inclination, as I say, is that the law firms will show remarkable adaptability, whether or not it's virtual hearings or paper hearings. The court systems, and I'm seeing in advanced jurisdictions, judges and policymakers recognizing that there's great benefits to be drawn from these technologies, but the real help that's needed is in frankly, the 54% who don't have access.
Well, Richard, I can't actually think of a better way to end this discussion than on that theme. And I'll just bring up our continuing interest in this, and really at the center, we really are looking in all three ways. How can we convene thought leaders, but also how can we change the way we're teaching those who are currently becoming lawyers to think about these issues in a way that is as broad as you are now suggesting. But this also ties into another major stream of research we have at the center that's on globalization and emerging economies. And I could not agree more that the last thing we should want emerging economies around the world is simply just to follow whatever it is that we have done in more developed areas, including the huge costly infrastructure that we've built up, which may or may not be working. And as you said, no one's ever empirically tested the current system. It's always the burden of proof is on change to have to empirically test that. But the current system itself has never been validated. And we see all over the world the opportunity for emerging economies, whether through mobile banking or entrepreneurship or microfinance or technology or community dispute resolution, or a whole range of things, to not just recreate, but reinvent what it is that we're trying to do in our justice systems. That is not to say, back to my something old, something new, something borrowed and not being blue, that there aren't things that are in the old system that are well worth preserving. After all, there's a reason we call it the rule of law, and we don't actually want rule of law 2.1 and then there's a glitch and you get a patch, and that's not the way we think about the rule of law. And actually in our world today, we're seeing the value of predictability, continuity, tradition, access in ways never before. But we cannot freeze these things in time. We have to figure out what the values are that we're preserving, and then figure out how to use the best of new technologies, the best of new ideas from around the world and from different areas to try to understand how to do what is still critically important, which is to provide the most justice to the most people that we can. I hope that everybody who has been with us throughout the day, or for as much as you have been able to join us, will agree that this conversation led by you, Richard, has really opened up tremendous opportunities to think seriously and critically about these issues. I want to give my deepest thanks to everybody who has made this possible, and I'm not going to embarrass them by making them turn on their videos, but I'm going to mention by name the terrific team at the Center on the Legal Profession who behind the scenes has made this all work incredibly seamlessly. That's Brian Fong, who's our research and executive director, Tim Shea, who's our lead writer for the practice, my fantastic assistant, Sarah Freeman-Aliman, Ralph Madlate, who's our research fellow, all of whom work tirelessly to assemble this great group of people and to make this conversation everything that it has been. I hope that all of you who are listening will continue to stay in touch with us. We're going to try to save the comments in the chat and the question and answers so that hopefully we can use this as a springboard for further discussions. We'll be reaching out to you for further events. We're going to make this webinar available so that even people asynchronously, Richard, so even people who were not able to be with us watching it today will have the benefit of the terrific conversation that you helped us begin. So with that, I will just thank you, Richard. Again, every time we work together, I feel that it is such a broadening and enlightening and thrilling experience. I hope others have felt the same way. I hope that everyone knows more about your work and the work of all the others who are involved here. And everyone will remember the memory of Chief Justice Ralph Gants, whose legacy we honor here with this conversation we've had today. Thank you all very much. And the program is now over. Thank you.